Court is now open. You may be seated.
Good morning, Ms. Miller. Mr. Howard?
Good morning, Chief Justice Marshall. Good morning, members of the Court. May it please the Court. Attorney Jason Howard on behalf of Mr. Bettencourt here on application for the appellate review. I'm here to tell the Court in no uncertain terms that Judge McLaughlin was correct in ruling that Mr. Bettencourt's motion to suppress ought to have been allowed. Mr. Bettencourt was a passenger in a motor vehicle stopped for a routine traffic violation on 140 North, heading north in the town of Taunton on September 9th of 2000, may have been 2002. Trooper Theodore and Trooper Doyle, they were patrolling that area. Trooper Theodore was a rookie state trooper for the Massachusetts State Police. He was being trained by Officer Doyle. Officer Doyle had encouraged Trooper Theodore to be on the lookout for any motor vehicle violations if he wanted to effectuate any stops for routine motor vehicle violations. Trooper Theodore testified at the suppression hearing that he observed that a black Chevy sedan operated by Miss Tina Reynolds lacked a front license plate. They effectuated the stop. Mr. Bettencourt, during the entirety of the proceedings, from observation 1 to observation 101, did absolutely nothing at all to place the officers, two officers, by the way, in any fear for their safety. He did nothing suspicious. They observed no gestures that he made. There was nothing to particularize suspicion with respect to Mr. Bettencourt.
So what should the police have done when they determined that she did not have a license and that there were warrants for her?
They did exactly what they ought to have done. Take her into the cruiser, Mirandize her, and transport her with respect to those warrants. The question then became...
And then he's there in the car.
What
should they have done?
The appropriate behavior would have been firstly, Commonwealth v. Alvarez says that request of the identification of the passenger in and of itself is a seizure that's unconstitutional if it lacks any particularized
So what
suspicion.
should they have done?
There are a number of options available to them. Constitutionally sound options available that they did not pursue. Firstly, sir, this car has got to be towed. Do you have a ride? Do you have a cell phone? Can you make arrangements? The problem...
You know, are we holding the police to specific words when they're out on the street and there are many things going through their mind and many dangers and inherent in the situation? Do they have to follow an exact script that they have to memorize ahead of time?
There is no exact script that I am pressing for. What I'm suggesting is that magic words is not what Mr. Bettencourt, what we are looking for. What we are looking for are objective standards applicable to police
Do you have
behavior.
a license? Is shorty in fact, can you drive the car? Do you want to drive a car? Do you have the ability to drive the car and the legal ability?
Correct, Your Honor, but in the circumstances of this case, we have Ms. Reynolds, who's in the back of the police cruiser, and the police are attempting to determine what to do with that automobile on the side of the road. The police, I would suggest, without Ms. Reynolds' permission, which firstly, in terms of objective, reasonable standards that we are asking the police to follow, not magic words, but in terms of how to remove this motor vehicle from the scene of the road, we're talking about Ms. Reynolds is in the back of the car. Presumably, and I think the car was registered to her, she is the owner of that car. The police, in terms of objective reasonableness, I would suggest cannot commandeer that car and give it to Mr. Bettencourt at all without first getting her permission. Commonwealth v. Alvarez relied upon a state of Washington decision. It had never been adopted by the Supreme Judicial Court, but it's the case of State v. Menninger from the Washington Supreme Court, when if we're talking about what should they have done, what objective standards are we looking for the police to follow?
But I understand if a car is stopped for a routine traffic violation and the passenger doesn't act in any sort of suspicious way that would lead to a reasonable suspicion that there's some danger, that the police have no authority to ask the passengers for identification. But that's really not this case. They stop the car. They arrest the driver for outstanding warrants. Now they have a car on a highway with a person in it. Don't they have some obligation to at least find out who this person is?
I would suggest they don't have an obligation to find out who he is. There is no who he is irrelevant to the motor vehicle stop. It's irrelevant to whether or not this car can be operated. Mr. Bettencourt could be John Smith. His identity is completely irrelevant. The question is...
Did Ms. Reynolds have her registration on her?
I believe it's fuzzy based on the transcript. I know that she did not have her license on her.
Correct.
With respect to the registration, I believe there was the findings of fact that Judge McLaughlin said that she did provide registration. I'm not entirely certain regarding that registration requirement. The hearing was a two-witness hearing. I think it lasted about an hour. The focus of everyone's attention, I would suggest, at the hearing was the reasonable suspicion attributable to Mr. Bettencourt, for which there was none.
But you started your argument by saying that your answer to me by saying the first thing they should have done was ask her what she wanted done with her car. We don't even know that it's her car, but we do know she didn't have her license with her.
We do know that, and we do know that the registration, there was no problems with the registration, because I know the police officer did a check on the registration. So, for example, it didn't come back recorded stolen or anything like that. There's no evidence that this car was wrongfully in the possession or being wrongfully driven by Ms. Reynolds. It was completely a question of she did not have her license on her person.
So they check out Miss Reynolds and find out she's got warrants.
Correct.
So they arrest her or seize her, and now the question comes, what do we do about this car, and what do we do about this other guy? It's permissible to say to the other guy, who are you, right?
No, I would suggest it is not
No?
permissible to ask him. Commonwealth v. Alvarez says quite clearly that requesting identification from the passenger is unconstitutional. Who he is, I would suggest, Your Honor, is simply irrelevant. He could be John Jones. I believe at the outset he said his name was Daniel Bettencourt.
So you say we got a case that flat out holds you can't ask him who he is?
Commonwealth v. Alvarez, it's not a Supreme Judicial Court case, but it is a Massachusetts Appeals Court case that says asking, and that was a situation where the driver and the passenger were both pulled over. They had some Florida identifications. The police officer was suspicious.
So what can they say to him? Can you drive this car? Can they ask him that?
I would suggest that there's objective standards. They can get to that, but it needs to be followed in an objectively standardized constitutional manner. Asking Mr. Bettencourt if he has a license, first off, given the facts of this case, they didn't necessarily ask him if he had a license. Trooper Doyle, who was there, who was listening to the interaction between Theodore and Mr. Bettencourt, said, do you have identification or a license? They're two
Mr.
distinct
Howard?
questions.
Didn't they say, we're going to have to tow this car if you don't have the ability to drive the car?
They told that to Mr. Bettencourt, but I would suggest that it's not his call to make. It's not anything that the troopers have to bring to Mr. Bettencourt's attention. The first and foremost is Ms. Reynolds. This car will have to be towed unless you can produce
She's
it.
under arrest. She doesn't even have a license at the moment, so she was driving improperly. They have a car on a public highway that they have to get rid of one way or another.
Correct.
So they have to find out as quickly as possible whether there's somebody to drive it.
And the first person to ask, under that Menninger case in Washington, and the appropriate person to ask is Ms. Reynolds, who the registration check that the police didn't demonstrate in any way that she wasn't the registered owner of the car, and didn't provide any evidence that that was being unlawfully driven. Ms. Reynolds, your car now is
But you concede, they did say to the passenger, either we tow this car or you have to have a valid license.
Well, that wasn't the first inquiry, was it?
The first
inquiry is, do you have identification?
Do you have identification? And then we need, and then somewhere along the line, Theodore said, do you have a license? And Mr. Bettencourt said no. Irrespective if they can ask him whether or not he has a license or not, I suggest they ought not have without first having confirmed with Mrs. Reynolds whether she wanted Mr. Bettencourt to drive the car. Where's his authority to drive that motor vehicle without the
Okay,
permission?
but now you're at the point where he says, no, I don't have a license.
Inquiry over, I would suggest, Your Honor, because, and this is something that the appeals court wrestled with in oral argument. They said, well, does that mean that he doesn't have a license on his person, or does that mean he doesn't have a license at all? Completely an irrelevant
You can't drive without
You can't drive without a license.
So they're supposed to just leave him standing there and let him figure out how to get wherever the hell he's going?
Well, I would suggest that what they don't do is simply impose upon him an obligation where now, let me find out who you are, let me pat frisk you, let me put you in the back of my cruiser
No, but
and
my
do you a
question is, are they
favor.
just supposed to leave him there, standing by the side of the road?
What road was this? This was Route 140.
140
It's
north,
a
right
highway.
around the Taunton Mall, though. They didn't even give him the benefit of, can you get transportation? Do you have a cell phone? Is there a parent? Is there a family member? Would you like us to call a cab for you? Would you like us to wait for you when the tow truck arrives? Would you like to travel with the tow truck?
So
There
it's
are a
all
host
right,
of
it's all right
permissible-
in your view if they then started asking him all those questions. Do you want to, do you want us to get a tow truck? Do you want to walk to the mall? Do you have a cell phone? Do you want us to call somebody? That would be all right?
It would be certainly a great deal more permissible than engaging him in an extended line of
But
conversation, telling him to come
Not
clean.
right to say, who are you?
Who he is irrelevant. Do you have a license? Yes or no? No. Over. The inquiry is over. Mr. Bettencourt, be on, or sir, we're towing
So it
this
would have been
truck.
all
You're
right
on your
at that
way.
point.
Do you have any?
Would have been all right at that point to leave him there. Just to say, okay, you don't have a license. We don't need to know who you are.
And then he gets hit by the
Goodbye.
next speeding car coming down the highway, and who gets sued?
Well, I think, believe
I
the standard
suppose
for...
that I suppose the inquiry here is: do you, in the exercise of your community policing functions, attempt to help a resident citizen if, for some reason, as far as the police know, has had no involvement in the illegal activities, potentially illegal activities of the driver? And your claim is the nature of the inquiries: who are you, and then we'll run a police check on you, is dealing with somebody as a suspect, as opposed to saying, sir, you don't have a license, you cannot drive this car. What, if anything, can we do to assist you to get to a place where you can get home? Correct?
I would agree with that. That, I believe, is what Alvarez, when it cited to Menninger in terms of the appropriate way to handle a situation like that. Because, again, he had not done anything at all regarding the operation of that car, regarding his own behavior.
Stated differently, Mr. Howard, I take it that you would say that there's a line of inquiry which is permissible, that has to do with community policing functions, which does not suggest that he be abandoned on a highway, but that he be assisted to get to some place where he can get home. And the way you don't go about that is by finding out his name and running a police check.
Right. I would
Well,
agree
how can the police assist him when they don't know who he is? They, as argued in the Commonwealth's brief, they don't want to put him in the cruiser until they know that he's not a safety risk. They certainly don't want to put him in the tow truck with an unarmed driver if they don't know who he is. So isn't that a very unrealistic scenario?
No, it's not, because he
But
had done
suppose
nothing-
he's some
he had
mad
done-
killer and they put him in the front seat of the tow truck next to the tow truck driver without running any check on who he is.
But why must we assume that a person who has completely been uninvolved with any of the underlying particularized suspicion with Ms. Reynolds is somehow a killer?
Taking an
is somehow
objective
anything?
standard, would anybody get in a car with anybody today without knowing who they were letting in the car? Would that be objectively reasonable?
It certainly would have been objectively reasonable to leave Mr. Bettencourt alone, to not engage him in this prolonged inquiry regarding who you are, let me run you for warrants, give me your right name, give me your wrong name. They were treating him like a suspect when he had done absolutely...
How does the Gonsalves case play into this?
The Gonsalves case had to do with a passenger in the back seat of a taxi cab. The taxi cab was stopped for a routine motor vehicle violation. The behavior of the passenger in the taxi cab was a little bit more suspicious, if at all. The court held that it wasn't. They said that he was acting nervous, that he was making gestures, ducking down, things of that sort. They said that inquiry of that passenger was completely impermissible, and anything seized from him ought to have been suppressed. Mr. Bettencourt, I would suggest, is in a...
Doesn't that support your position?
Yeah, he's in a much better position than Mr. Gonsalves.
I see possibly in places like Holyoke, Springfield, Lawrence, cars being stopped with 5 Hispanic drivers, 3 or 4 other Hispanics, and the police impound the car because the driver, doesn't have a license, registration's no good, something like that. And then they say to all the others, okay, let's find out who you are. We're going to run criminal checks on all you. I mean, this could be limitless.
I would suggest it's completely impermissible to follow the behavior and the conduct of Trooper Theodore and Trooper Doyle.
In the absence of any conduct on the part of the passenger that gives them some reason to be concerned about their safety or some other legitimate factor.
And he had done completely nothing wrong. And if we're talking about objective, reasonable standards, the question becomes, how do we treat Mr. Bettencourt? Correct, the car will have to be towed.
Mr. Howard, can I ask you this question?
Yes.
Could you address the waiver issue for me?
I shall, Your Honor. At the motion to suppress hearing, the question, the arguments advanced by the Commonwealth in support of Trooper Theodore and Doyle's conduct was that he was visibly shaking, and he was visibly shaking. He had given one name, and then after 2 hours of 2 minutes of conversations, he gave a different name.
And no eye contact, right?
Yeah, no eye contact. He didn't. Yeah, he didn't stare directly at me. He just had a conversation, I think, through the window of some sort. And based on shaking and giving one name and no eye contact, because they didn't know that name that he had given Daniel Bettencourt.
In other words, the argument, as I understand it, the argument of the Commonwealth was
he was
suspicious activity.
correct. And then, as this case has gone along, it's transformed from suspicious conduct to.
And isn't that exactly what the Superior Court judge said? He addressed that argument. He said, yes, but the suspicious activity, to the extent that it's suspicious, occurred only after there had been an initial impermissible, in the judge's view, examination.
That is correct. He had held that under Commonwealth versus Alvarez, the request for identification or a license, which is what was requested there, because it goes back, this whole community caretaking became an explanation after the fact, because when Theodore went to Mr. Bettencourt on the passenger side, he didn't simply ask for a license or identification, and I believe it's at page 38 of the transcript where Trooper Doyle says that we wanted to know who he was. Well, I would suggest...
I assume that we accept, unless it's clearly erroneous, the judge's finding, in my view, that at no time had the defendant engaged in suspicious activity. That is not challenged by the Commonwealth, correct?
I don't believe it's been challenged by the Commonwealth. I believe that argument's been abandoned, and in their most recent brief to the appellate court of this court is that it was permissible by virtue of community caretaking, that they should have searched him, taken him into the back of the cruiser.
So when
they were
did
doing him
community
a favor by arresting him.
when did community caretaking become the argument, the basis on which the Commonwealth says this was appropriate search?
In the application for interlocutory appeal that was deferred to the appeals court, it was only then and only that it transformed from reasonable suspicion to community caretaking. And even under community caretaking, they simply weren't doing him a favor by searching him, seizing him, and putting him back to the cruiser. There are a lot more objectively, legally permissible ways to handle this that they didn't follow.
Thank you, Mr. Howard. Ms. Blackman?
May it please the Court. My name is Tara Blackman, and I represent the Commonwealth. The first issue I would like to address is the last one discussed by my brother, which is whether or not this issue was waived by the Commonwealth because it was not raised. The Commonwealth would suggest, in fact, that this issue was present all along. All along, the issue was present whether or not there was a non-investigatory purpose for the officer's questioning, finding out whether or not the defendant and passenger.
If we look in the record, did the Commonwealth file a memorandum in front of the trial judge?
Yes.
Are the words community caretaking mentioned in that memorandum?
No, Your Honor. The words community caretaking are not, but the point is addressed when in the memorandum it's stated that the officers were looking for someone, a licensed driver, to drive away the car, or the car would need to be towed, and this was communicated to the defendant. Whether we say it under the words community caretaking...
Was there oral argument in front of the judge before the motion was decided?
I believe there
Were
was...
the words community caretaking used in that oral argument?
I do not believe the precise words community caretaking were used, no. But the point was addressed, whether we call it community caretaking or we call it something else.
That makes a big difference. We don't just jump labels around.
No. Did the judge mention the words in his memorandum? I think the answer is no.
The words were not mentioned in the memorandum, correct, Your Honor, but there was a non-investigatory purpose.
Let me just ask you this question, which is a factual question, Ms. Blackman.
Mm-hmm.
As I understand the judge's memorandum, the police went to the passenger side of the vehicle and asked the defendant if he had a license.
Wait a
minute, that was the first question. So let's assume that there's a purpose to see, can he drive the car away, which, as Mr. Howard suggests, may not have been the best way to determine that, because you might have asked the owner, the purported owner of the car. But let's assume, and he says no. No. Right? Now, the police know that this man cannot drive that car. Whether or not it means no, I don't have it on me, or no, I never had one, just no. Right? The next thing they did was, what's your name? And then ran a check on him. That's what the motion judge was considering, correct? And as I understand, at least his ruling, that at no point did the Commonwealth say, well, Judge, here's the problem we had. We didn't want to put him in the car without knowing who it was. He could have been a serial killer. We weren't trying to find out how to get him to the nearest fast food convenience store. What we wanted to do was see whether or not he had some outstanding warrants. That's not community policing. What is it about that next series of interchanges? It's assumed that you raised the question that said this falls within community policing functions as the law has developed.
Well, the Commonwealth would argue that once the defendant stated he did not have a license on him, which can be found in the transcript, that was the answer. The police officers did have some discretion within Chapter 90, Section 11, to find out.
Isn't the next question, how are we going to get you out of here?
Well, presumably the...
There's nothing in the record, as far as I can see, that suggests to me that that's what they had in mind. If they just said to him, how are we going to get you out of here? What are we going to do with you? Not magic words, but something that says to me, I'm going down a community policing road, not I'm going down a are you a criminal road.
Well, in fact, the first thing the defendant was informed of was the fact that he would need to either produce a license or that the vehicle would be towed. At that point, when the defendant states, I don't have ID on me either, at that point, presumably it's...
But that was in response to a question.
Well, from the transcript, it seems that that information was actually, it would seem that that was actually volunteered by the defendant at the point that Trooper Theodore said to Trooper Doyle.
Well, I think I've got a finding by the judge that information was given in response to a question. I mean, are you saying that that's a clearly erroneous finding?
No. The Commonwealth would argue that nothing turns on that because, in fact, it's irrelevant because the officers were merely asking, the defendant was told why he was being either asked or told that he needed to produce a license.
Doesn't this really stand for the proposition, if you win, that when the police stop and legitimately arrest the driver, seize the driver, and impound the vehicle for whatever reason, they can then get the identity of everybody in the car and run a check on them through the criminal records computer? And that, I suggest, goes way beyond what we've held.
No, Your Honor, because the defendant was informed of the reason for this, just as in State versus Manager, the person was informed of the reason. Now, it's true the sequence of the questions here were different than in State versus Manager.
He was informed why they were running a criminal records check on him?
Well, actually, the Commonwealth would argue that it was not for the purpose of a criminal records check. It was, in fact, to find out if the defendant had an active license. And
he's just told them he hasn't.
Yeah, he said, well, I don't have a license.
No, Your Honor, respectfully, according to the transcript, it says that, in fact, he doesn't have a license on him either. Simply because he's not driving with a license on him does not mean he does not have an active license.
He cannot drive that car without a license on him.
Well, the Commonwealth would argue, as it argued in its brief, that if that's the way that Chapter 90, Section 11 is construed, then it gives police officers very little discretion in allowing someone who actually has a license but merely forgot their license and registration at home to continue on rather than incurring the expense of a tow. And the Commonwealth would argue that that wasn't the legislative purpose in enacting.
So your position is the police could have, if they confirmed that he did have an active license, they could have let him drive off in the car even though he didn't have it on his person?
Correct, Your Honor.
Ms. Blackman, let me ask you this question. You just said no to Justice Graney's, does this mean that they can get the identity of everyone in the car and then run a criminal records check? Help me understand where the Commonwealth would see the limit as to that, not on the facts of this case, but now you're in someplace else and there are 3 or 4 passengers in the car, right? Well, what's the limit? What's the limiting principle here?
Well, I think the limiting principle here is if the people in the car said at that point, no, we don't want to drive the car, or we have a way of getting something that didn't happen in this case. But if those people said, we don't want anything to do with this, we have our means of transportation. But that was not the defendant's response in this case.
What about if a police officer says he went and asked the police if he had a license, the defendant said no, right? And the record is that the police officer then said, you just don't have it on you, or you don't have you've never had a license. He says, no, I've never had a license. Okay. Why can't the police accept that? This is somebody who's, in essence, saying, I don't want to drive this car. There may be good reasons why he doesn't want to drive the car, by the way.
If it was actually, which it's not clear from the record at all, but if it was the case that in fact it was clear to the officers that the defendant did not have a license whatsoever.
But why do you have to run a criminal history check to find out if somebody has a license?
Well, it was simply the minimally intrusive questions of asking name and date of birth, and there's a reasonable reason for that. And the reason for that is that all along from beginning to end, there were only two options available to these officers. That was to have the car towed or to have the passenger drive away the vehicle.
Did they actually ask him if he had a valid license?
That was not, no, that is not from the transcript. It stated that he needed to produce a license, and at that point he said that he did not have him on him. ID on him either.
I have a question on a slightly different subject. The appeals court decision says that the exit order was for the police officer's safety. As I understand it, the Commonwealth is arguing that the exit order was because the defendant had to leave the car no matter what happened. And what is your position at this point?
I would say that it's both. I would say that it is a combination of both. One, it's irrelevant because the passenger at that point needed to exit the car no matter what, because he couldn't just stay in the passenger side of the vehicle. He either was going to drive the car away or he was going to be transported by the officers who were going to take them in their cruiser somewhere where he could find a safe place to be left. However, it's still, at that point, we get to the point of whether or not, at that point, the officers had some suspicion and whether they should have asked him to exit the vehicle. And they still were reasonable in asking him to do so. Because at that point, after asking this minimally intrusive questions of name and date of birth, the defendant started acting extremely suspicious, giving a false name.
Do you agree, you don't argue, do you, that any of the judge's factual findings are clearly erroneous?
I would say that they are, because I would say that...
Have you argued that?
Oh, no, the factual findings, no, I apologize. I apologize, Your Honor.
No, I
not
know the
factual
legal
findings.
conclusions are being debated.
Does the record indicate whether or not the call that was made by the police officer for identifying information about the defendant could have been made at different levels, or different levels of inquiry could have been made? In other words, could a call have been made just asking for whether or not he had a valid license? Or is there only one call that could be made that would produce all kinds of stuff?
If you make that call, you'll get outstanding warrants. Correct? I'm pretty certain about that.
Right.
In other words, you can't
Well, can I have the answer to the question, though?
That is whether or not a different sequence of questions could have been...
Can the officer call or dial in computer, I don't know what he has in his cruiser,
Right.
the registry of motor vehicle to check on registration and license?
Yes.
And will that spit back outstanding warrants having to do with non-driving offenses, for example?
Well, generally, yes.
Yes, it
Well,
will.
the check
It
that
will
they
in all
run, yes.
instances. I mean, it may
Excuse me,
sometimes...
I'm sorry, I want to explain further.
The check that they generally run when checking, and I actually had spoken with the police about this, and when they run the check, they check both license and...
But they could just check
together.
one. They just happen to run both checks.
They always run both.
They always run both, but they could just run one.
That's not clear.
Well, I'm asking.
Yes, they could. I believe that it may be possible, but that never is not in practice what happens.
Ms. Blackman, are you saying that either way, either if he had a license, they were going to check to see if there were warrants, or if he didn't have a license, they would still check to see if he had an active license, and so they'd be checking for arrest warrants in either instance?
Well, in either instance here, yes, because in fact of the situation, they can't be taking, as Justice Cowan pointed out when Mr. Howard was arguing, these officers are not asked to risk their safety, and here, this would have meant putting...
In either case, they do it anyway. I mean, if they stop anybody, first question is, show me your license and registration. And then the police officer, I mean, I've been through this, goes back to the cruiser, and you're sitting there for 5 minutes, and you know darn well he's checking that license and checking whether you've got a record and whether the license has been suspended and a whole bunch of things, and then he or she decides whether they're going to write you a ticket or give you a warning or whatever.
This must have been in Westfield someplace.
I take the Fifth Amendment on where it was, but I've been through this. But they do it in every case, is my point.
Well, they do it for the driver.
for a driver.
They're perfectly entitled to do that for a driver, correct?
Correct. They're perfectly entitled to do that for the driver, and in this case, they had to transport
In fact,
the passenger.
that in some sense is one of the not entirely illegitimate, I mean, not at all illegitimate reasons why people get stopped when there's some indication that they're driving, one of these vehicles, which are very dangerous vehicles, and something is wrong. We always say, well, it's just a tail light. A tail light is very important, right? It helps save lives, for one. Your answer to Justice Cordy, though, you haven't helped me, in any case, understand what the limiting principle here would be. In other words, Justice Glaney's question was, if we agree with you, doesn't that mean that when there's been a valid stop, a valid arrest, the car's on the highway, even if it's on a road, right? It's not near somebody, the person is without transportation. Would the result, if we rule in your favor, be that the police are thereby authorized to ask every passenger for identification, license identification, and then run a criminal records check?
Well, it depends. I would say that it's all of the surrounding circumstances.
Tell me where the limiting principle is. I can't just say to all the trial judges who listen to the evidence, Judge, Superior Court Judge, you got it wrong on this one. You did it very carefully. You went through step by step, which we've asked you to do. But, well, I guess it's just, no, you got it wrong. Tell me where he got it wrong.
I would say that the limiting principle is they are allowed to find out if any person in that car has a valid license.
Every single passenger in the car, the police can ask for identification and run a criminal records check.
That was my point, yeah.
They can ask if they have they could ask if they have a license, and a better question than the question asked in this case would be if they had a valid license.
They can ask if they had a license if there's a need for that person to drive the car. If there's
Well,
three people in the car and the first person says, yes, I have a license, then they don't need to ask anybody else anything.
Exactly, you're right, exactly.
So your limiting principle is once there is no passenger with a valid license, they can run a criminal records check on everybody.
I would suggest no. I would suggest not if the circumstances don't warrant. And these people, well, in others, these are a unique set of circumstances. In other circumstances, the passengers might say, no, we have another means of transportation.
But he was never asked. He was never asked.
No, but that doesn't mean. But here, maybe if it had been asked, the police officers would not have gone on to ask for the name and date of birth. It's also the case that not every case is going to be in the middle of a highway in rush hour traffic. A lot of cases are going to be on a street where someone has a way of getting.
Does the record indicate that the police officer was planning to drive this defendant off the highway to some other location if he did not have a license?
The Commonwealth would argue that.
Does the record show that this is what the police officer intended to do?
No, Your Honor. They did not. They never stated this was our plan. But presumably that's what they would have had to do. Take this defendant into the police cruiser, completely unrestrained, not knowing who he was, with a companion who had just been arrested.
Why couldn't they have let him walk away?
Because that would have been completely negligible on their part to allow somebody to walk away and leave someone in the middle of a highway in rush hour traffic.
I mean, you can ask. Do you want to walk? Do you want to ride? If you want to ride, I'm going to run a criminal history check on you.
And maybe a different sequence of questions would have been optimal, Your Honor. The Commonwealth does not argue that this was the perfect sequence of questions. However, the Commonwealth argues that this was a reasonable sequence of questions. It was reasonable before asking whether the passenger wanted to drive the car away to find out if he possibly could, if he had an active license. Because, of course, if he did not have a license to drive the car away, he could not take the car.
Go ahead.
For these reasons, if there's any other questions, otherwise, the Commonwealth urges this Court to reverse the Superior Court's.
Thank you, Ms. Blanton.
You're welcome. Thank you.